morning, and thank you for joining us. My name is Kelly Weiner, and I'm a partner at Scott Legal PC. And today we're going to talk about how to obtain a green card based on company sponsorship, specifically focusing on the PERM, EB-2, and EB-3 categories. A few housekeeping items before you get started. Some of you may know that Scott Legal was founded on an E2 visa several years ago. Our founder is in the US on an E2 visa and has been on several different visas, including F1, TN, B, and H1B. Scott Legal is a full service immigration law firm, and we offer immigration services in a number of areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB-5, PERM, extraordinary ability visas, and more. At the end of this webinar, we'll send out a few useful tools, including this PowerPoint presentation, a link to where you can download guides that go through visa options in more detail, a link to where you can sign up for additional webinars, and also this webinar will be recorded and made available on YouTube, and we will send you the link for that as well. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos. We will also send you a link to where you can set up consultations if you'd like to speak to an attorney at the firm. As I mentioned, my name is Kelly Weiner, and I'm a partner at Scout Legal, and I have processed many different EB-2 and EB-3 PERM cases. If you have any questions throughout the presentation, please send them to the chat box or Q&A, and we'll reserve time at the end for questions. And without further delay, let's get started with the webinar. All right, how do you obtain an employment-based green card in the US? So we've listed out here some of the employment-based categories that are most common, and I'm going to run through them in a bit of detail, but really focusing mostly on EB-2 and EB-3. We do have other presentations that go over the other employment-based categories in more detail. So for the EB-1A, this is an extraordinary ability green card that's available to people who have achieved sustained national or international acclaim and risen to the very top of their fields. Generally, this is demonstrated by showing you either have one major prize or award, like a Pulitzer Prize or a Nobel Prize, or showing you meet at least 3 out of 10 criteria, demonstrating your extraordinary ability. There's the EB-1B for outstanding researchers and professors. This is often used by people who are coming for tenure track positions at US universities. There's the EB-1C, multinational manager or executive. This is for anyone who has been employed by a company outside the United States in a managerial or executive role for at least 1 year before entering the US to hold a managerial or executive role at a US company that has a qualifying relationship with the company abroad. There's the EB-2, and there's two kind of subcategories here. The EB-2 category, as a threshold matter to qualify, you must have either an advanced degree or exceptional ability. Advanced degree means a U.S. master's degree or higher or equivalent, which would be a U.S. bachelor's plus 5 years of progressive post-baccalaureate work experience. Exceptional ability is a slightly lower standard than extraordinary ability. You show you'll meet at least 3 out of 7 criteria. Once you meet that threshold requirement, there's 2 ways to qualify for an EB-2. One is through something called a national interest waiver. This is where you ask the government to waive the normal labor market test that they have to conduct for this type of green card. So for a national interest waiver, the applicant is saying that they are engaging in an endeavor of substantial merit and national importance to the United States, that they themselves have the background that shows they're well positioned to advance this important endeavor. And then based on that, they say, we'd like you to please waive the normal labor market test, either because the normal labor market test doesn't work for me because I'm an entrepreneur, or because the work that they're doing is so important that even if other US workers could work on this, it's better to have more people working on it because it's an issue of such importance to the United States. The other way to qualify for an EB-2, we'll talk in more detail later in the presentation, but that's through the PERM, which is company sponsorship. This is where a US employer is going to sponsor a foreign national for a permanent role in the United States. And to do this, they have to go through a labor market test, which we'll go over in more detail later. The EB-3, this is for professionals, skilled and unskilled workers. Professionals means that the job requires at least a US bachelor's degree. Skilled workers means that the job requires at least 2 years of education, training, or experience. And unskilled workers is when it requires less than that, less than 2 years. and there are less green cards available in the unskilled workers category. In order to get a green card through this category, you do have to go through the PERM process, which is again where the US company is going to sponsor the foreign national and conduct a labor market test to make sure there are no willing, qualified, or available US workers who could hold that job. The EB-4, this covers a variety of different categories, including, for example, religious workers who come on R1 visas and maybe want to transition to a green card. And then there's EB-5. This is an investment-based green card and based also on the creation of U.S. jobs, where you are either investing 800,000 or $1,050,000. And then showing that you will create 10 full-time jobs over time in order to get the conditions removed on your green card. All right, let's talk a little bit more about the PERM process, also called the labor certification process or the labor market test. So the EB-2 and the EB-3 categories are the main way that U.S. companies can sponsor foreign nationals to work in the United States. It is a three-step process. The first step is the PERM, which has multiple steps within it and can take quite a long time to be approved. The second step is an I-140 petition, which is filed with U.S. Citizenship and Immigration Services. And then the last step is the I-485 or consular processing, which is the step where the applicant actually applies for their green card. So let's talk about the PERM first. So to start the PERM process, the company needs to draft a PERM compliant job description. This means the company has to determine what are the minimum requirements to do this job in a reasonable manner. So while lots of job descriptions may have things like great team player, goes above and beyond, you can't include those kind of subjective requirements in a perm job description. The job description really has to be tailored to say, if I had to hire somebody for this job off the street tomorrow, what is the absolute minimum requirements they would need to have to do this job in a reasonable manner? Because the government wants to ensure that when you do the labor market test, that the job is as open as possible to any qualified or willing or available U.S. workers. Once you've drafted the job description, then you can go ahead and file for the prevailing wage with the Department of Labor. This is where you submit the job duties, the job requirements, the location, and the Department of Labor will determine what the proper occupation code is, what the proper level is, and tell the employer this is the minimum wage that you can pay to the person once they get their green card in the future. Once you have the prevailing wage determination, you can actually start the recruitment process, also called the labor market test. This is where the employer is actually going to have to place advertisements, depending on whether it's a professional position or non-professional. It's either 3 advertisements or 6 forms of advertising, all of which are kind of dictated by the law and regulations. So it's not kind of a normal recruitment process for the company where they can just post anywhere they like. There's very specific places they are required to post, under the PERM process. The recruitment process is 60 days at a minimum, so 30 days where kind of the ads are running, and then 30 days of where the company is still having to review resumes, interview anybody who looks potentially qualified, but the ads are usually not running by that time. If at the end of the 60-day period, the employer does not find any qualified, willing, or available U.S. workers for the job, then they can go ahead and file a labor certification with the Department of Labor. They will essentially attest to say, we posted these ads. We did not find any willing, qualified, and available U.S. workers. Therefore, we would like to move ahead with sponsoring this worker for the job. Once you file the labor certification, you will be waiting for some time. Right now, they're taking about 15 to 16 months to adjudicate those petitions. So when you're thinking about your timeline and when you want to get the green card, you want to build that timing in because you will potentially be waiting for a year or more to even hear back to see if the labor certification is approved. Once it's filed, it can either be approved or also called certified. It can be denied or it could be audited. And there are some audit triggers we've described here. So for example, if the job requires a foreign language and it's not a job like a Spanish teacher, then normally that will trigger an audit. Also, if you have requirements that are outside what the Department of Labor considers normal for an occupation, this could be another audit trigger. There's also just trends that happen throughout the years where sometimes they will, frequently audit unskilled workers, or sometimes they'll audit people on certain types of visas. So it's a good idea to just keep in mind what are the trends, at this particular point in time for the Department of Labor. All of these PERM related filings are done with the Department of Labor. They're not with U.S. Citizenship and Immigration Services. So the timing for this is all based on the Department of Labor. And as I mentioned, it is a multi-year process. So often can take a few weeks to draft the job description. It takes about 6 to 8 months for the Department of Labor to issue the prevailing wage determination. The recruitment process is at least 2 months. And then the labor certification is at least 15 to 16 months and could be more if the case is audited. Because if it is audited, then the company will have to prepare a response within 30 days and send in documentation to answer any questions the Department of Labor has. If the case is certified, then you can move on to the next step, which would be filing the I-140 petition. The I-140 is a form that is filed with U.S. Citizenship and Immigration Services. It's filed by the employer, and with the I-140, they have to file with proof that they have the ability to pay the prevailing wage and that they've had that ability since the PERM was filed. So this is going to include things like the company's tax returns or audited annual reports, maybe the employee's W-2s if the employee already works there and earns, a similar wage. All of this will be filed with the I-140. The I-140 will also include proof that the applicant meets all the requirements that were listed in that PERM job description. So if the PERM job description required a bachelor's degree plus 2 years of experience, the I-140 will need to include proof that the applicant has that bachelor's degree and employer experience letters describing their experience that they earned prior to joining the PERM employer. The I-140 in terms of timing, can take several months up to and over a year to be adjudicated. There is also an option to pay an additional fee to get an answer within 15 business days. That answer can be an approval, denial, or request for evidence. If it's a request for evidence, you'll provide the evidence, and then a final decision will generally be issued within 15 business days. The last step is the I-485 or consular processing, which is the step where you apply for your green card. So in terms of timing, the question you'll have is your category current or not? So in the EB-2 and EB-3 categories right now, there is a worldwide backlog. That means that none of the categories are current. So there's only a certain number of employment-based green cards that can be issued in any given year. And because of the number of applicants, there is somewhat of a backlog in waiting. Because the labor certifications are taking such a long time, if you are not in one of the countries with an extensive backlog. So, for example, people born in India, people born in China are facing quite extensive backlogs in the EB-2 and EB-3 category. But if you're just in the worldwide category where there's a delay of, a year to 2 years, because of how long the labor certification takes, by the time you get to filing your green card, it may be that your category is current, or it may be that your priority date allows you to file. But you do want to kind of keep that in mind just in terms of, do you need to extend your underlying status, because you may get to the stage where your I-140 is approved and then you cannot proceed yet because your priority date is not current for the green card application. Family members can join in on your green card application. They can, any your spouse and any unmarried children under 21 can join you either with the I-485 filing if they're in the United States or through consular processing. And we'll talk about these two green card processes later in the presentation. All right, so adjustment of status and consular processing. This is the green card part of the process. So you've successfully gotten through the labor market test, successfully gotten the I-140 approved, and now you're filing for the green card. And there's two ways to do this. One is through adjustment of status. This is only available to people that are in the United States in a status that allows for adjustment. So let's say that, your underlying visa status had run out, but the company is still sponsoring you, and you've been traveling in and out on ESTA as a business visitor every now and then. You will not be able to adjust status in that circumstance because you cannot adjust status from ESTA. A much more common scenario is people are already working for the U.S. employer. Maybe they have an H-1B, an O-1, an E-2, some type of work visa. And in that instance, you can file for an adjustment of status with U.S. Citizenship and Immigration Services. The benefit of this is once you file it, you're able to remain in the United States. So even if your underlying visa status runs out and you can't renew it for some reason, like if you're on a TN and it's not possible to renew, filing the I-485 means you can continue to stay in the United States. In fact, you have to stay in the United States because if you file the I-485, and then you leave the United States before you get approved for travel authorization, your I-485 will be considered abandoned. There is a minor exceptions to this for people on H-1B or L visas. You also, when you file your I-485, have the ability to file for work and travel authorization. And then at the end of the process, you'll have an interview with a USCIS officer who will ask questions about the job, make sure that the job is ongoing, and that you're still planning to pursue the position that was outlined in the PERM application. The other option to get your green card is consular processing. This may be a good option for someone who, for example, is on an E-2 visa and needs to travel a lot for work and cannot, wait for their travel authorization to be approved. Or perhaps for somebody who their work visa ran out, they had no ability to renew it, and they are now working remotely outside the US or working somewhere else while they wait for the green card process. So consular processing will happen outside the US at a US consulate in the country where you reside. Once your I-140 is approved, that approval is sent to the National Visa Center. There's an online form called the DS-260 that you will fill out, and you also will submit supporting documents to the National Visa Center, things like birth certificates, marriage certificates, police certificates for anywhere you've lived, court documents if you have any criminal history. Once the National Visa Center reviews the documents, the file will then be sent to the U.S. consulate, and the consulate will then schedule an interview. The applicant will also have to attend a medical exam, and then the medical exam results will be sent to the consulate. And then you'll attend the interview, and if it's approved, then the consulate will put an immigrant visa stamp in the person's passport. Generally, it's valid for 6 months. They need to enter the United States in that period of time, and then the green card will be mailed to the applicant after they enter the US on that immigrant visa. All right, a very common question you receive is who can pay for green card fees? And fees related to the PERM process, including legal fees and other fees like fees paid to post advertisements, all have to be paid by the sponsoring employer. The government does not want to incentivize employers to, go through the sponsorship process by having employees pay for that process. They want if the employer wants to proceed, the government wants the employer to be the one taking on the burden of paying for that. However, once you get to the I-140 petition and the green card petition, either the applicant or the employer can pay for those. All right, let's talk a little bit about dual intent. So what is dual intent? Dual intent is when the government allows somebody on a temporary visa to also have the intent to remain permanently in the United States. There are many visas which do not have dual intent, where you can be denied for your visa application if they feel you intend to remain permanently. Things like the TN, the F1, they have a very high standard that says the applicant needs to show that they have a residence in their home country that they do not intend to abandon. So there's many, non-immigrant visas that do not allow dual intent. Which visas do have dual intent? So the H-1B and the L explicitly have dual intent. So if you're going through the green card process and you're on an H-1B or you're on an L, that's really the best status you can be on in the sense that you do not have to worry about being questioned at the border, about your intent in the US. If your green card application is pending, you can continue to travel freely. You do not have to wait for travel authorization to be granted to you. The O is listed here. I'd say it's what we call kind of a quasi-dual intent visa. There is some very favorable language in the Foreign Affairs Manual and the regulations that says that it's not a bar to being granted an O-1 visa, that you are also pursuing a green card process. That being said, it doesn't have some of the benefits of the H-1B or the L. For example, if you're on an O-1 visa and you file an adjustment of status, you cannot travel without travel authorization. Otherwise, your application will be denied. You'll be considered abandoned. All right, let's talk about some considerations when moving from a visa to a green card. So one is timing and underlying visa status. So you always want to consider how much time is left on your current underlying visa. For example, if you have a 3-year TN, but you only have 1 year left on it, and you're just about to start filing for the perm, you're going to have to extend your TN because, the perm process is going to take more than a year to get you to a stage where you would actually have some other status you could rely on. You want to just be mindful about planning. For example, if you're on an H-1B and you're coming up towards the end of the 6 year limit, you want to be thinking about that. Maybe around year 3, you want to start planning for that to ensure that you're far enough along in the green card process that you could extend your H-1B if needed, or that your green card could be filed, your green card application could be filed before the 6 years are up. So you always want to be kind of thinking proactively, especially because the perm process is so long. It is a multi-year process, and is kind of getting even longer as there are more green card delays. So really kind of talk to your employer. If you're on a TN, maybe they're willing to enter you into the H-1B lottery, so that you can switch to an H-1B, to kind of go through the green card process on an H-1B, which is easier than on a TN. You want to think about, do you want to adjust status in the US, or are you okay getting the green card through consular processing? If you want to adjust status in the US, you need to make sure you have that underlying status that allows you to adjust. If you're fine kind of being outside the United States for a while and going through consular processing, and talk about that with your employer to see if they are also okay with you having some period of time where you potentially are, maybe not work authorized in the US or living abroad. Always want to think about your family. Do you have children that you want to join your green card application? If so, you want to consider filing early to avoid any issues because your child will age out of eligibility at 21, or if they get married. All right. So at the end of the green card process, you generally are going to have an interview. With an adjustment of status process, it is sometimes the case that the interview is waived. We're seeing that less and less now in this new administration, where there is an increased focus on enforcement. We anticipate that most people will be interviewed, for their employment-based cases moving forward. If you go through consular processing, you will always have an interview. It's not possible for the interview to be waived. So things you should consider before your interview. So, review your immigrant visa petition. This includes kind of your PERM application, your I-140 petition, the green card application you submitted. Organize and print documents to bring to the interview. Generally, your appointment notice will list the documents they want to see. And we also usually recommend bringing copies of the filings, or what was made available to you from the company from the filings. Gather any required original documents, so birth certificates, marriage certificates, if you're sponsoring family members, things like that. Ensure that your medical exam is completed. So the new requirement is that the medical exam for an adjustment of status has to be filed at the same time as you file your I-485. So just that should be, shouldn't be an issue at the interview stage, but if they do ask for it, making sure that you have it. Getting updated proof of employment from your sponsoring employer. So bringing either I-485 Supplement J, confirming the job offer, or perhaps bringing a, something on letterhead from your employer confirming the job and that they still plan to offer you the position, from the perm. Proof of maintenance of status. So if you're adjusting status in the US, one thing you need to demonstrate is that you yourself have not violated your status. If you have, there might be some relief under a section called 245K, but you would want to discuss that with your attorney before you go to your interview to make sure, really before you file any petitions, to make sure that you know what your options are. If for some reason the type of violations you have, mean that you cannot adjust status, you may still be able to go through consular processing. But if you are adjusting status in the US, proving that maintenance of status is very important. Also, a good idea to meet with your attorney and do a practice interview. Even if you feel very comfortable with all the materials, it can be a very nerve-wracking situation. And so it's a good idea to practice with your attorney or with someone else just to understand how you would answer certain types of questions. All right, porting and changing employers. So what is porting? So this allows employees to change employers once the I-485 green card application has been pending for at least 180 days. So this is a benefit that you can get kind of at the end of the green card process. Many people will come to us maybe when they first started their perm, or maybe about to file the I-140 and say, can I change employers? And if I do, what benefit will I get from the green card process? So unfortunately, if you change employers when the perm has been filed, there's really nothing you can do to preserve any aspect of that. With the I-140, it's a bit different. Sometimes you can preserve your priority date if it's filed and approved. But at this late stage of the green card process, so once you've gone through the perm, the I-140 is filed and approved. The I-485 has been pending for at least 180 days. At that point, you can port to a new employer as long as you are porting to a job that is in the same or similar occupational classification as the job offered in the I-140. So for example, if you were a, senior accountant and you are porting to become a senior accounting manager, this is likely fine. This is, very good argument that you can have, the same or a similar occupational classification here. However, you could not go from example being an accounting manager to, an owner of a restaurant. So there are some limits, but it is a benefit that you get at the end of the process, that you could potentially port to a new type of role without having to go back and do the perm again or do the I-140 again. All right, changing employers after obtaining your green card. So another very common question is, once I get my green card, do I have to keep working for the sponsoring employer or can I change jobs? And the answer is that once you have your green card, you can work anywhere in the United States, including for yourself. There is not a requirement that you continue working for the company that sponsored you for the green card. That being said, when you apply for your green card, you are making a good faith attestation that you intend to keep working for this company in a permanent role. So if there is some reason that you leave that job, you want to have some explanation for why. The place that this usually will come up is during if you decide to become a U.S. citizen in the future through a process called naturalization. If you go through the naturalization process, the officer will also look back to, for the basis on which you got your green card. If they see in the work history something that looks suspicious or something that makes them think there was some type of fraud or misrepresentation, that's what you would want to avoid because that could be detrimental both to your naturalization application and to your underlying green card status. So generally a good idea if you get a green card through employment that you continue working for your sponsoring employer for some length of time. There is no required amount of time, but again, generally at least several months. And then if you do leave, you would want to have some explanation for why you left, whether it be, your spouse got a job in another state or you were offered a more, a job with more money or a promotion somewhere else. But you do want to keep that in mind, particularly if you got your green card through a job and then you go into an entirely different field. You just want to be aware this is something that could come up in the future. All right. So we have reached the end of the presentation, and I don't see any questions that have come in. So we will close here. I hope everyone has a wonderful day. Thank you.